actually better. This is much better. Because we all want to ship in. Are we ready to resume? You can continue eating. To try and tie all the points we've made earlier together in the paper, we've put together 4 problems that we thought we'd discuss, and we've all had an opportunity to read through the problems. And we have about, we don't have as much time as we originally thought, but we have made perhaps about 5 minutes per the four problems each. And what we thought we'd do is just ask the audience to go through what are the options that the clients have, and what are the factors that would govern each option, and try and stimulate some kind of discussion. At the end of that, we'll go externally and see whether the people who have joined us through video conferencing have additional points. The problem number 1 just is a formation of a law firm, Shingle and Shake LLP, or Shingle and Shake Professional Corporation. They're undecided what they want to do, and they have a variety of concerns, and they come from disparate backgrounds. Shake is concerned about his personal liability for anything the solicitor might do, which is Shingle. And Shingle also expects to do some income splitting with his wife and 3 minor children, and he has some savings. But Shake lives in a same-sex relationship and spends more than he earns. And what are their options, and how are Shake's concerns best addressed? Anybody with to go over what options these clients should be looking at?
Anybody want to dive in?
Pardon me? Stay separate. That's a very good option. That is an option, and there's a variety of ways of doing that. They could just rent office space. I mean, we don't have to be stuck to the program. They could stay separate, rent office space. Could they do a joint venture? Be a bit dicey. They might be recharacterized as a partnership, so they have to be careful of that one. Traditionally, there would have been a general partnership, and that would have been the only option. But nowadays, they have other options. What are those other options? Right, a professional corporation under the OBCA. Part 3 of the OBCA is an option.
Should probably repeat it.
I think what you're describing then is a professional corporation that would operate the firm, that would be owned by holding companies that the individual, the 2 lawyers would own. I actually don't think that that's available because of Part 3 of the Business Corporations Act, professional corporation. The shares in the professional corporation have to be owned by the licensed professional. So that is one option. I don't think it is available, but there's similar things you could look at. For example, you could have an LLP, which would be the firm, which would be owned by professional corporations, which is one of the. All right, that would be one configuration. Any other configurations? Simpler ones, maybe. The professional corporation could be the actual business. That would be another option, and it would be owned by those 2 individuals. What about their family members, though? Especially Shingle, who wants to do some income splitting with his wife and children, minor children, who can't work in the business by his nature. Okay. Not going to work very easily. That's right. That's right. I mean, we can get into fancy things. I think some of us have seen limited partnerships and so forth that can split off a bit of income from firms through management fees and that sort of thing. But for a firm of 2 lawyers, to put that kind of structure in place, is something they would have to look seriously at. And also, there's a difference between the 2 partners. One doesn't have any savings and no income splitting, or maybe not as much income splitting need.
I think it should be pointed out that the income splitting opportunities, excuse me, in the short run are perhaps limited in that there is the so-called kiddie tax, which would limit, if you had, say, a management corporation or a limited partnership that provided management services to this firm, any income that came out for the benefit of minor children would be taxed at the maximum individual tax rate. So what you would try and do in this case is split income by having Mr. I forget which one it is, Shingle, I guess, have his share of the management corporation or limited partnership that provides management services. His income would go to his wife. In Mr. Sheikh's case, if the relationship is sufficient to generate the other partner to be a spouse, there might be some possibilities there too.
Mm-hmm. Yeah. Well, let's look at Mr. Sheikh, who is concerned about liability issues. So what about these two? What about these alternatives in that regard? In other words, which one should he be looking at, and which one should he be concerned about choosing because of his liability concerns? For example, the professional corporation, does that offer him much protection against the liability concerns that he has? Anybody? Some? That would be the case with respect to the limited liability partnership, the LLP. That would be the vehicle to use if he's concerned about the liability of his partner. For the professional corporation, it's not going to protect him. It would protect him against trade creditors if he was concerned about that. What about, just staying with this one for a second, what about if they were positioning the corporation or the business for a sale? For whatever reason, they were selling to another practitioner and they were approaching retirement. Would there be any consideration there?
Just generally.
Would there be any considerations there that should be entertained by them if they were positioning this business for a sale? That's right. I think that's...
Yes, and again, just remember that there are 2 prongs to that capital gains exemption test. When they do the rollover, they don't have to meet the 2-year holding period test, but they do still have to meet the asset composition test. So, for instance, if the practice had a lot of, say, term deposits because of retained earnings, you would probably want to hold those back and not roll them into the corporation because that would perhaps generate too much in the way of assets that were not used in an active business.
We've been reminded that we should, if you're going to ask questions, you can use one of the mics that's at the front, or we'll repeat the question, whichever you prefer. Can we then look at the second problem, which is the establishment of Canadian widgets? Smith & Wesson are leaving their present employer, which is a widget manufacturer, to establish their own manufacturing operation, and they have approached you to consider their options. They'll have some funds in order to start this operation, but they'll need more money to buy some special tooling. And they have different family and personal needs and interests. What business vehicles should these entrepreneurs consider, and what are their options down the road? Anybody first to canvass the options?
form of partnership and corporation just for the benefit of ILN attendees has just been suggested, but with corporation being the best alternative.
And why would you choose those?
First of all, it's a manufacturing. This is easier. First of all, it's a manufacturing company, so for liability purposes, I would incorporate. As well for flexibility, having two people that are working in the company, it seems that both of them are going to be active, so that's not really a big issue, but in terms of later on down the road, they can issue pref shares for venture capital purposes.
I think she's nailed that one pretty well. Then problem number 3 is Smith & Wesson have done very well with their corporation, and they've been approached now by American Widgets, which is a multinational listed in the United States, and the American Widgets wants to acquire the Canadian operation. Smith & Wesson, they want to sell shares in order to realize they followed your advice and they did form a corporation, obviously. They want to sell shares, not assets, but American Widgets wants to acquire assets. For the price that it's paying, it wants to optimize its own tax position. And is also concerned about undisclosed liabilities, particularly product liabilities, which is another factor that you mentioned as a factor for incorporating. And it's also concerned about liability for the executives, liability for executive determination at Canadian Widgets. Again, what business vehicles would American Widgets be considering and why? This is something we really didn't get into a great deal in our presentation. Anybody got some ideas about what they might want to look at and why?
Hold on.
I'd probably get the American company to set up a Canadian sub, just to protect, if it's a well-established American business, just to protect its assets. And then I would agree with it that it should buy assets of the Canadian Widgets, just to eliminate the inherent liabilities that would come through on a share purchase. I think that's probably like the biggest issue.
I think I'll ask Jerry to maybe expand on that.
Okay, well, what about, can I stay with you for a second? What about the fact that the vendor wants to sell shares?
I think that probably the American large multinational listed company would probably have more of a bargaining position, so they'd probably get their way.
Yeah.
Perhaps the vendors could, or the company could sell its assets to a company owned by the vendors, and the vendors would then sell the shares to the American company.
Sorry, roll it down to a subsidiary?
Or another company that's owned by the vendors. So they could take advantage, I'm just thinking of a way they could take advantage of their capital gains exemption.
Well, there are going to be some problems with, if you want to get the capital gains exemption, there are firstly some restrictions on reorganizations that you can do. And the exemption's only available on sales by individuals, so they'd have to be selling at the top level. But I think, frankly, the question is going more to assuming that they want to sell shares, is there a way that we can accommodate them and get what we want? Any comments? Yes.
Just 1 second. Our ILN delegates can't hear unless we use a microphone, so.
The Americans could set up a company, their sub, and buy the shares from the other company. That is the Canadian Widgets, could be bought by American Widgets Canada. And in that situation, they'd have a completely different setup, and they'd probably be protected against the executives at Canadian Widget.
But what would happen to the assets in the target company? There would be no write-up of the value of those assets for tax purposes.
Well, you know, you indicated that you wanted a share transfer,
Right.
and the share transfer would bring the assets with them at a depreciated value.
Okay. I think just to cut to the chase, I think this is not something that we discussed in our presentation just for the sake of time, but one thing, one possibility here is the use of a Nova Scotia unlimited liability company. And I think that I mean, you are quite correct that if we're going to buy shares, excuse me, there's going to be no write-up of the assets except in limited circumstances. If in the case of non-depreciable capital property, if we acquired the shares and then wound it up into another Canadian company, we might be able to increase the cost, but generally speaking, not. The advantages of the ULC are really completely U.S. in nature, in that for Canadian purposes, the ULC is still treated as a corporation. So if the company was converted into a ULC and then sold, the vendor would get the capital gains exemption, and the company would still be a corporation, a Canadian corporation in the hands of the purchaser. There'd be no write-up in the assets for Canadian purposes, but for U.S. purposes, a ULC can qualify to be what's called a disregarded entity. In other words, the Americans would just pretend that it didn't exist, and for American purposes, it would be treated as basically an asset purchase. So for U.S. tax purposes, the Americans would get a high rate or a higher base for depreciation in the U.S. Now, they still have to deal with the Canadian tax liability here, of course. And the other thing that they would have to take into account is if it's an unlimited liability company, you would want to have a shell American company buy it to limit the liability. And then, given it's a disregarded entity, that American shell would report the results in the United States, try to get a foreign tax credit for whatever taxes that were paid in Canada, and I believe would then consolidate with the other corporations in the group. But as I say, the advantage of the ULC, is purely U.S. in nature. What it does do is give the Americans, in this case, the U.S. Asset treatment, but it still allows the individual to get the capital gains exemption in Canada. Sorry.
So I would have phoned you first, and then I would have found out something about the Nova Scotia thing, which I first saw, I think, 6 months ago.
Yes.
There's a great deal more about Nova Scotia unlimited liability companies in the paper, including both the tax, some of the U.S. tax uses made of it, and also the corporate law considerations that you should also be aware of. The final question then is Maxim Developments, Inc. This is a family of consisting of two brothers who've been in business for a long time and over several decades have acquired a large portfolio of commercial and industrial properties. They also have their wives and children as shareholders of their companies. They've done well, but they've decided that the time has come to start liquidating their investments. They're concerned about that there may be a battle for control, which is not unusual. We think of the recent Waxman case that went through the courts for about 15 years here. And they're concerned about there might be a battle for control amongst the cousins once the brothers retire or pass away. They want to keep some of the land, but they want to take the opportunity to realize their accumulated profits on the commercial and industrial properties. And they also have decided that the real estate market has reached a peak. So what options should the Maxim family consider in liquidating their portfolio of revenue-generating properties, and why? Anybody wants to list off the options that they should be looking at?
Yeah, the ILN people.
Anybody from Ottawa, London, and the other ILN locations? I don't have the list. We also have Thunder Bay and Waterloo.
Standing room only.
We're still at dinner?
Still lunch.
Can we have Thunder Bay and Waterloo up?
Well, Toronto.
Well, how about the audience here? All right.
Any comments from Waterloo?
No?
Have we heard from Thunder Bay yet? Can we have Thunder Bay, please?
Would we hear them even if we can't see them? Okay,
Here's your answer.
Okay.
let's just dive into it then. Let's just.
Shall we just proceed here and see whether we can crack this nut and figure out what options the Maxim family should be looking at? Anybody?
A suggestion in the audience about the amoeba splitting, like a Section 85 reorganization, where perhaps the future growth of the company can be split from the by preference shares. I just like the amoeba splitting. I'm not an expert in this area, but
Sounds like a great idea to me.
Well, I was referring to what's called a butterfly reorganization, basically where you have the two groups of shareholders. There is a means whereby the two groups basically could end up with a corporation each, so they would basically just take their separate shares of the assets, and as long as they stay in a corporate form, so in effect, if you take this company divided into two companies, one branch of the family takes one, the other takes the other, that might be a possibility. I guess the difficulty then is, well, you know, what about the management expertise? Is that split equally between the two groups? Are they able to do that or not? I mean, that's a practical consideration. Right, I mean, you know, they just talk about the management expertise in the question. It doesn't say who has it. If Brother A took his stuff and Brother B took his stuff, you know, I suppose they're both expert, but we don't know.
I was thinking that the two elder brothers that started the business who have expertise in developing, they talk about vacant
Yes.
tracts of land, would have one chunk, and then the income-producing properties would be split off separately. So the expertise would stay in the
development chunk.
and that would keep the undeveloped tracts of land where they have the most potential to increase the value of the asset.
Yeah.
Then the income-producing assets that are sort of separate would be hived
Yeah.
off to the cousins.
Yeah, okay. Anything else? Not all the way to Thunder Bay.
Just for the benefit of the ones that are still watching.
The brothers would, if there was a butterfly situation, they'd save 35 or 40%. If their children are unable to handle the money or the business, they could very easily give it to a management company, the commercial and industrial stuff, and the 35 or 40% that they're going to save on the butterfly will pay for the management for a very, very long time, 4 or 5% or whatever the numbers are today, and they'd be well advised to. The brothers seem to be getting along all right, and they can perhaps still stay and use the skills that they have, which is the development part, and produce some more.
Thank you very much. The two suggestions that have been made so far are primarily directed at what can they do to retain their interests and maybe split them between themselves but retain the properties. But the question was really what the question was really driving towards was a sale vehicle for the family to try and liquidate their investment.
I think what they're looking for is an estate freeze where there's a trust that's set up, and then when you liquidate, there'll be all the family members as beneficiaries of the trust will take advantage of the capital gains exemption. If it's probably not a small, well, does it matter if it's a small business corporation? If the shares go into an estate freeze?
Well, one issue that lurks in the background here, frankly, is it's not so much with the industrial properties where they're getting the rental income, but the land development business is a concern. There is case law to the effect that if you're a land developer and you sell shares, that just as you'd get ordinary income on selling the land and not a capital gain, so too you may get ordinary income selling the shares, in which case you don't have a capital gain. There may be no capital gains exemption. That's one factor that has to be considered here as well in terms of you know, the use of a trust in that manner.
We don't have much time left. I think David has gotten off pretty lightly so far, so could I maybe ask David to maybe speak to this issue?
Well, I think one other point I might just make about the estate freeze possibility is I think the facts indicate that the brothers at least seem to believe that the real estate market has reached a peak. And so as far as the bulk of the portfolio of properties goes, it looks like the likelihood of future appreciation maybe isn't really terribly great. So I would have thought that it's not an obvious situation for using a freeze. Again, typically in a freeze case, you'd be expecting some capital appreciation. I think the other possibility here might be the possibility of thinking about the use of an income fund here to as a possible vehicle to acquire at least the properties that they're interested in selling, the commercial and industrial properties. I think that's maybe where the question's trying to point you. Has anybody got any thoughts on how that might work? Well, the question is, I think maybe one possible vehicle for dealing with the liquidation of these properties, the sale of these properties, would be to use an income trust. And my question is just how might an income trust fit in this scenario?
I think we'll leave that one for the experts.
Well, I think one possibility would be, again, we'd be talking about a trust that's a publicly traded type of trust and that would issue units to the public in return for consideration, which could be used to acquire the portfolio of real properties. This is the type of asset, at least historically, has been the type of asset that would be very attractive for a business trust like a REIT, a real estate investment trust that is a trust that's going to hold a portfolio of income-producing properties, provides a good stable cash flow. It's the kind of thing that would have investor interest. So one possibility might be to create a vehicle of that type to acquire at least the properties that they're interested in selling. I suppose one possibility as well might be that the properties that they think still have development upside might remain behind in the existing company, and they might look at doing a freeze of those portfolios if they think there's some prospect of appreciation there.
I feel like I'm one of those talk shows. Would it be worth it to sever the two sort of classes of properties? The way I understand it, if a property is sort of one of these operating companies that or operating property that has income and there is not development potential, but it is in the process. For example, you've submitted plans to the city for, or at least you had some intention and can demonstrate that you have done a considerable amount towards developing it for sale. It gets a different kind of a tax treatment rather than the other kind that's just sitting there vacant without any, I guess, development much further in the future. Is there a different tax treatment for the two different kinds of properties? I understood there was, but I may be wrong.
Well, I think the fundamental question is whether the person involved is a trader in real estate or not. And if they've had a history of land development and sale, that would be a problem. But if you, I mean, I don't think there should be any meaningful difference between just holding vacant land for a long period of time or you're probably, in a sense, maybe in a worse shape, you know, taking it further steps toward development. I mean, on the other hand, the rental real estate could be treated as capital property, so you'd get a capital gain there. I mean, the one thought I had just on this is that, you know, I don't think the development real estate would be an ideal candidate for an income fund, obviously, but the other thing, it talks about the management expertise of the brothers, and certainly some sort of a management contract between the brothers or the brothers' company and the REIT or whatever it is that is set up would be a means for them to capitalize on their expertise.
Can I ask another question then? Let's say we go with a REIT and the income-generating properties are spun out and the original company, it's consideration for that. One of the concerns these folks have is that there are family members in the business with them and they're worried about what is going to happen upon their retirement and infighting breaking out in the family. What do we do then with the company Maxim? It has properties for development and proceeds from the formation of the REIT and family members still as shareholders. Where do we go from here? Is there a way we can go from here to perhaps take out these other shareholders to clean the company up to solve those problems? Or are we stuck with them?
Well, those are good questions, and you may have some more flexibility than you had previously because, of course, you've got some liquid assets that could be used to be given to those family members who are not going to be actively involved in the business to try to achieve some kind of equity and balance within the family. And you could look at a smaller pool of the family members, maybe the original two brothers, not much beyond that perhaps, to looking at the development properties. Alternatively, to pick up on Mr. Tenenbaum's earlier point, you could also look at splitting those development properties into the respective families so that some of those concerns will be alleviated. There might be some butterfly transaction there.
I think also to the extent there's proceeds, you'd probably want to get them out of the company and maybe each family, each branch of the family having a holding company on top that would get the proceeds from the receipt from the REIT sale dividended up to those holding companies so they could be invested independent of each other might be something to think about.
Someone discussed USA to address a concern about boundary for control.
I'm sorry, I didn't hear the question.
The question was, could we discuss the application of a shareholders agreement, presumably at, what is it, Maxim, at the Maxim level, to help them deal with the sort of disputes about control, battles for control? How would the USA work in that situation?
Well, those are good questions. If they decide to, I mean, it's a little bit hard to answer that in a vacuum, but you could look at all kinds of structures. You could look at trusts, again, to create an equity interest in it, but without any voting control, so that the trustees are still in control. You could look at capital structures involving non-voting shares, for example. That could be used. You could again look at splitting the assets out into the two different families, or some combination of it. You could look at some kind of a shotgun provision in the shareholder agreement that if there was a fundamental breakdown in their relationship, they would have exit strategies. All of these tools could be used, but I think that's part of the dust would settle a little bit once you realize what percentage of their total wealth is going to be liquidated, and how much you're dealing with that. It's, you know, these development properties, what are they worth at the end of the day compared to that?
I think we've reached the end of the road. That was the last question, I believe. Oh, sorry, we have an ILN question, do we? Could you read it?
I just had one question from someone, a written question. Let me just read it. it says husband and wife each own an operating company, that is one each. Does the appointment of each spouse as the power of attorney for property for the other impact upon the access to the small business rate? That is to say, does it cause the two corporations to be associated? So if husband owns one corporation, wife owns another, they should not be associated to begin with. There is a rule in the Income Tax Act, 251(5)(b), that says if someone has a right to acquire shares, or what's relevant here, to control the voting rights of shares, whether it's worded quite broadly. Let me just read you the language, the preamble. It says a person has a right under a contract, in equity or otherwise, either immediately or in the future, and either absolutely or contingently, a right to acquire shares or control the voting rights of shares. Then they're deemed to be in the same position vis-a-vis control of the corporation as if they owned the shares. So I suppose the technical answer would be that if someone has a power of attorney and therefore a right to vote the shares contingently, that may catch you. However, excuse me, I think my answer to the question is I don't know. I'd want to look at whatever rulings revenue has on this, and I guess I'm sort of inclined to think that just an ordinary power of attorney may very well not cause you to fit within that, unless the intention is that you're going to vote the shares. David, I don't know if you
I don't have the language in front of me, but the word that caught my eye was, or caught my ear, was contractual. I'm not sure that an ordinary power of attorney, for example, for power of attorney for property for estate planning purposes would be viewed as being a contract.
No, it says contract, comma, in equity or otherwise, comma. So it's quite broad.
Yeah.
I'd be inclined to think, unless it was specifically intended to be used in the near future, that it probably would not be a problem. But on the face of it, the legislation, I think it is technically an issue. So I'd want to look at revenues, see if revenue has any specific commentary on this. So whoever asked the question, if you want to leave me your card, I can take a look at it and get back to you. Thanks.
Terrific question. We've reached the end of the scenarios. We do have a couple of minutes for questions if anybody wants to ask any more. Otherwise, Stephanie, do you have any final remarks before we close today?
I just wanted to give any of the locations a chance to ask any questions. So if we could just
Fair enough.
quickly roll through the three that are left. I believe
Right.
it's Ottawa, London, and Waterloo.
Great.
Thanks.
Ottawa, London, Waterloo.
Or Windsor.
Okay.
Thank you.
That takes care of that. Thank you.
Okay. Thank you very much, everybody. And please, thank you. There are, as Stephanie said at the outset, there are feedback forms in your materials, and it's much appreciated if you complete them and leave them behind. Thanks so much.